Thank you very much. Good afternoon and welcome to the Senate Committee on Government Affairs. Thanks to everybody joining us online today. We appreciate your participation. Members and audience, please remember to mute your microphone when you are not speaking. And will the Secretary please call the roll?
Vice Chair Orenshaw.
Present.
Senator Goycochea.
Here.
Senator Neal.
Here.
Senator Hansen.
Here.
Chair Dondero Loop.
Here. Thank you very much. All members are present and we will move on. First, before we begin, I want to briefly remind everybody about the ways to connect with us through this virtual platform. Remember that you can participate in a committee meeting through Nellis, and it places you in line to testify on a bill. You can also submit written testimony. You can share your opinion via the legislature's opinion website, and you can view committees online through Nellis or on the legislature's YouTube channel. As we move through the meeting, if you have any difficulty, please make sure you reach out to our staff. And when you get ready to speak, if you are doing so, please remember to pay attention and the BPS will let you know when it is your turn to speak and how to press and unmute yourself so that they can call on you to speak. We have a period of public comment after our bills, and at that time, we will be limiting your speaking to 2 minutes per speaker. And today, the committee will be hearing 2 bills, and then we'll have a work session following that. So with that, we will begin by opening Senate Bill 45. This measure revises provisions relating to crimes, and I believe our bill presenters are ready to begin. Please go ahead.
Hello, good afternoon. Can you hear me? Great. For the record, my name is Jessica Adair, and I'm the Chief of Staff for the Nevada Attorney General's Office. And today I am joined by my colleagues, First Assistant Kyle George and Nicole Riley, who serves as the Attorney General's Domestic Violence Ombudsman, to present Senate Bill 45. Senate Bill 45 is a bill intended to enhance the state's ability to combat domestic violence in the state of Nevada. And I think it is just a fitting coincidence that we are hearing this bill on the first day of Women's History Month. In 2019, 30,357 domestic violence offenses were reported to Nevada law enforcement agencies, according to the Department of Public Safety's Uniform Crime Report. This represents one domestic violence offense reported every 17 minutes and 18 seconds. This shocking number does not account for the many domestic violence offenses that go unreported every day. At the Attorney General's Office, combating domestic violence and supporting survivors is a key priority that we achieve in several ways. Nicole Riley has served as the office's domestic violence ombudsman for several years, managing many statewide programs on domestic violence and assisting individual victims by connecting them with services and even holding their hands in court. Attorney General Ford also chairs the statewide Committee on Domestic Violence. This committee is comprised of diverse stakeholders and experts who help lead the way on domestic violence awareness and identifying gaps in legislation, services, and systems that support families experiencing domestic violence. This bill helps strengthen both the services provided by the Ombudsman and the committee. I would like to bring this committee's attention to an amendment provided by this office. This amendment reflects changes approved by the Committee on Domestic Violence and other stakeholders. And turning to the amendment itself, Sections 1 and 2 expand the duties of the Ombudsman to include services provided to victims of sexual assault and human trafficking, in addition to victims of domestic violence. These expanded duties reflect a common reality that many victims of domestic violence also experience sexual assault and trafficking. Service providers, law enforcement, and other stakeholders frequently serve these victims as well. It is critical that we do not work in silos and support a more comprehensive approach to victim services. the Office of the Attorney General does not have any victim services staff dedicated to sexual assault or human trafficking. So this will allow our office to serve many different kinds of victims seeking our help during their time of need. And as a reminder, our office does have concurrent jurisdiction over human trafficking offenses. Section 3 clarifies that while the Ombudsman will have expanded duties and serve victims of domestic violence, sexual assault, and human trafficking, the account created to support and serve the Committee on Domestic Violence will still be focused solely on domestic violence programs. Section 4 makes several changes to the Committee on Domestic Violence to better serve the committee's goals. First, while the Ombudsman of the Office of Attorney General will serve victims of sexual assault, human trafficking, and domestic violence, the committee will continue to focus on domestic violence issues. That clarification is made throughout the amendment. Second, the amendment adds 2 critical members of the committee. Subsection 9 adds a representative from the Office of the Court Administrator. From protective orders to sentencing, the courts are a key partner in the judicial response to domestic violence, and adding this member will facilitate communication and a better understanding of domestic violence. Subsection 10 adds a representative of the Department of Health and Human Services Division of Public and Behavioral Health, who has experience in the certification of programs for the treatment of people convicted of domestic violence. This section goes hand in hand with subsection 2B, which removes the committee's statutory responsibility of certifying treatment programs. Currently, those who are convicted of domestic violence offenses must attend treatment programs as part of their sentence. Those programs are recommended by the committee and then officially certified by the Division of Public and Behavioral Health. This bureaucratic process is inefficient and also often leads to a delay in certification as the committee meets quarterly. And one of those meetings is dedicated to the statewide fatality review. This bill would place the responsibility of certifying treatment programs solely with the professional staff at the Division of Public and Behavioral Health. Yet appointing that staff member then back to the committee will maintain the communication and shared expertise between the program certification staff and the committee itself. For example, the committee is currently conducting a study on the efficacy of these treatment programs. Having the certification staff on the committee will help inform the study, and the study results will help inform the work of the staff who certify treatment programs. Subsection 2E adds a statutory duty to the committee to study and consider the intersection between domestic violence and other issues, such as sexual assault and human trafficking. And the remaining changes to Section 2 are technical changes to improve the committee's efficiency. Sections 5 and 6 make conforming changes. And Section 7, subsection 4A, makes a correction to the sentence for those convicted of domestic battery against a pregnant victim. In the 2019 session, this legislature passed Assembly Bill 60. Assembly Bill 60 was sponsored by the Attorney General's office and made many sweeping changes to the domestic violence statute. One of those changes created a new crime, domestic violence against a pregnant victim, when the offender knew or should have known that the victim was pregnant. This is in recognition of research that shows that homicide is one of the leading causes of death of pregnant women. Additionally, pregnant people who experience domestic violence have greater health risks due to their medical condition. And pregnant people experiencing abuse are also more likely to delay prenatal care. NRS 201.481 states that a first offense for a domestic battery against a pregnant victim is a gross misdemeanor. The standard sentence for a gross misdemeanor is incarceration from 1 day to 364 days. In practice, this is leading to absurd and unjust results when compared to the mandatory minimum and maximum sentences for misdemeanor domestic violence or battery if a victim is not pregnant. Under NRS 200.485, a first-time misdemeanor domestic battery offense is punishable by a minimum of 2 days incarceration and a maximum of 6 months. A second-time misdemeanor domestic battery offense is punishable by a minimum of 20 days incarceration and a maximum of 6 months. Because the standard sentence for a gross misdemeanor is incarceration from 1 day to 364 days, a person convicted of the more severe crime of domestic battery against a pregnant victim, gross misdemeanor, could be incarcerated for a fewer number of days than a person convicted of a standard misdemeanor battery. This is not fair, and it defeats the intent of this statute. On the other hand, punishment of 364 days incarceration is heavy-handed for a battery that did not result in substantial bodily harm, particularly considering the maximum for a standard misdemeanor is 6 months. This amendment seeks to strike a balance that is fair, just, and reflects the intention of the statute. The new sentence proposed for a first offense of domestic battery against a pregnant victim is a minimum of 30 days incarceration and a maximum of 6 months. The statute also clarifies that offenders must attend treatment programs like those who are convicted of standard domestic violence battery, and the fines associated with this statute are also equal to the fines for a standard domestic violence battery. Thank you for hearing our bill presentation, and we look forward to answering your questions.
Thank you so much for this information. Committee, do I see any questions?
Oh, sorry, Madam Chair.
Senator Neal, please go ahead. It's Monday. It's okay.
I know. I had a question on, it was the behavioral health language that was in the bill. I believe it's in section 4, but it's the sub B. I was trying to understand, so this is new. So what do you seek to gain by having the representative now a part of this conversation?
Thank you, Senator Jessica Adair, for the record. And the reason it's sub B and not under the other list is because that person is not appointed by the Attorney General, but rather the administrator of DPPH. That's why it's separated in that way. What we seek to gain here is a greater communication between the Department of Public and Behavioral Health, who are already certifying these treatment programs, and the Committee on Domestic Violence. So one of the things that this committee has already been looking at and wants to improve is the efficacy of these treatment programs. So when someone is sentenced under the domestic violence statute, they must attend these treatment programs, formerly called batterers intervention programs, that seek to break the cycle of domestic violence, so not just punishment, but also rehabilitation. And what we're finding is that some of these programs are really effective. Some of these programs are not very effective. And we're trying to make sure that the programs that are certified by this state as batterers treatment programs are effective. And that's something that the Committee on Domestic Violence takes very seriously. I also have here with me the Domestic Violence Ombudsman, Nicole Riley, who can speak to this question probably more articulately than I can.
Thank you for that. Madam Chair, can she address that? Because I guess what I was trying to find out, because, they're commas, so it's domestic violence, sex trafficking, sexual assault, and then sex trafficking. And so it says the person who has committed the act. So I guess I'm trying to understand, what's the reformation of someone who's a sex trafficker and a certified program for that?
Yes. So thank you, Senator Jessica Adair, for the record. I think that that language might be a remnant of the old language, and we need to strike sexual assault or human trafficking. It should only be for the treatment of persons who commit domestic violence. That is in accordance with the rest of the statute that sentences people to commit domestic violence to those treatment programs that are certified by DPPH. So I can make that clear in a further amendment if you wish.
Okay. Thank you, Chair.
Thank you. Additional questions from the committee? I actually have one. I'd like some clarification on, you were talking about, and I'm not sure what section it was. It might have been, actually, I think it was on page 8, like section 7, Section 4A, where you're talking about the imprisonment issues. So when you were talking about that, it changes the penalties for not substantial bodily harm. How do they know with the mental health piece of that? We know what bodily harm is, right? We can see the bruises, we could see the actual things that have happened to a person, but how do we generate mental health into that and somebody's fear and somebody's other pieces because perhaps they haven't been hit, but they've been beat down in a mental way? If you could answer that, that would be helpful.
Thank you, Chair. Jessica Adair for the record. So the reference to substantial bodily harm is taken from other references in NRS. In terms of domestic violence, there is a separate statute that addresses domestic violence battery that results in substantial bodily harm, and that is a B felony. In terms of the mental distress, you're right. That is so difficult for a court to quantify. But I think when we're looking at a battery, we really are looking at the physical harm that is suffered by the victim. And that is standard in NRS when it comes to battery statutes, whether domestic violence or otherwise. I think, though, that the harm committed towards a victim is something that a judge and jury would take into account when sentencing someone to any crime, including these statutes. But just for clarification, I want to walk through the 4A a little bit more in detail, or just reiterate what we're trying to get at. So right now, in the standard domestic violence battery penalty scheme, a first-time domestic violence offense is a minimum of 2 days incarceration and a maximum of 6 months. A second-time domestic violence simple battery within 7 years is a minimum of 20 days incarceration and a maximum of 6 months. The third time is a B felony. In this statute, the gross misdemeanor for domestic violence against a pregnant victim, the sentence could be anywhere between 1 day and 364 days, because that's a standard sentence for a gross misdemeanor. So what we have in practice are judges who are sentencing someone to this gross misdemeanor crime at a lesser amount than what they would be sentenced under a standard domestic violence battery. And that really defeats the purpose of the statute, and frankly, it is unjust. But on the flip side, you also have someone who could have committed a battery, domestic violence battery against someone who is a pregnant victim, be sentenced to up to 364 days, so virtually a year, when that person did not commit a crime of substantial bodily harm, which is a separate statute, the B felony. And that's what we're trying to rectify here. But to your question, Chair, about mental harm, what the NRS is focused on in terms of battery really is bodily harm. So I hope that provides a little bit more clarity.
Thank you very much. I appreciate that explanation. Additional questions from the committee. Vice Chair Orenshaw, please go ahead.
Thank you, Chair Dondero Loop, and thank you for presenting the bill to General Ford and to your Chief Deputy Attorney General and Chief of Staff. My question on with the enhanced penalty that was passed in AB 60 for a domestic violence battery against an expectant mother, has there been any tracking? Do we know if there have been many prosecutions of these kind of cases? Have there been, a checkerboard of sentences that have been less than if it had still been a misdemeanor? And do we know if maybe has there been a preventative effect? Have there been less incidences of these batteries on pregnant mothers since the passage of AB 60? I wonder if any of that's tracked.
Thank you, Senator Jessica Adair, for the record. So I do have anecdotal evidence that there are offenders who are being sentenced to a sentence that is less than the standard misdemeanor, and that's actually what brought this bill or this portion of this bill. In terms of overall stats, I don't have that. I was just looking at the UCR data, and the DPS has not published that yet for 2020. And I'm hoping that when we move to NIBRS, we're going to get more discrete data on this crime in particular. But given that the law is new and only went into effect in October of 2019, we just don't have more comprehensive data in terms of the prosecutions and also in terms of any deterrent effect.
Thank you. Thank you, Chair.
Thank you very much. Additional questions from the committee?
Chair, I just had one more.
Sure, absolutely.
Okay, so Ms. Adair, I had a question. There was language in, I believe it's on page 5, and it was a review and evaluate existing programs by peace officers for training related to domestic violence, sex assault, and human trafficking. And I guess the question is, who's reviewing the peace officers, and then what is the standard? Because it says recommendations by post, but whenever I watch like the, I guess it would be the finance meetings, they seem to be, not have a lot of time to implement certain things because they haven't implemented certain things that we brought up for, I think it was implicit bias. And so I'm wondering how will this work going through post, I guess, and then who is reviewing them outside of post?
Thank you, Senator Jessica Adair, for the record. So that is an existing statutory duty for the committee. And in the amended version of this bill, we remove the references to sexual assault and human trafficking. So it's only domestic violence. So this bill does not seek to change any of the statutory duties of the committee as they relate to recommendations for programs for peace officers. In terms of who is making those recommendations, this committee includes many different stakeholders, some of whom we do have a representative from the Nevada Sheriffs and Chiefs Association, courts, judges, district attorneys, and other stakeholders. In the past 2 years, under AG Ford's tenure, we also created a training subcommittee that reviews and addresses training issues specifically, whether that's peace officers, court officials, judges, schools, etc. So that's in terms of who is already doing that, the Committee on Domestic Violence as a whole and the training subcommittee. In terms of the ability for peace officers to absorb and implement and attend trainings, we know that that is an ongoing issue that we hear all of the time. Peace officers, by nature of their job, have a difficult time getting off of work in order to attend those trainings, even though it is part of work. We know that many localities have problems making sure that they have coverage and also having folks attend training. That was something that we actually put in our recommendations when we did a statewide fatality review of a fatality 2 years ago in Tonopah. Was an issue with the Nye County Sheriff's Office having limited number of deputies in that area to be able to attend programs for training. It's an ongoing problem. But in terms of what this bill is directed at and what the committee does, it's an existing statutory duty that seeks to enhance the quality of training programs for domestic violence and work with POST in that regard.
Thank you very much for that information. And just as a note to committee members, there is a proposed amendment on Nellis. So that is there for us to review. So that is what Ms. Adair is reflecting on or speaking to. Is that correct?
Yes, Chair, that is correct. Though I will say that legislative drafting might not be one of my strongest skills, as Senator Neal already pointed out, one of the things that I missed. So I'm happy to work with LCB to ensure that this is up to snuff. But no, we did submit an amendment that does reflect what I was speaking to when I went through the bill section by section earlier in the presentation.
I just wanted to confirm that, and thank you very much for that. We appreciate that. Any additional questions from the committee? Okay, well, if we have no more additional questions from the committee, we will move to support, opposition, and neutral. And so if you will stand by, we'll give broadcasting just a minute and we'll move into that. Thank you very much.
Good afternoon. Thank you. Callers, to testify in support of SB 45, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 650, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Liz Ortenberger, LIZORTENBURGER, and I'm the CEO for SafeNest. And thank you to the Attorney General's office and to the committee for hearing this bill today. SafeNest is a domestic violence agency in Clark County. We regularly serve over 25,000 victims of domestic violence each year. We are unique as an agency because we also serve batterers in the domestic violence space. We're in support of the name change and the overlapping duties in the Ombudsman's title because we see every single day the overlap between domestic violence, sexual assault, and human trafficking. As a provider of batterers treatment, we are also in support of having a new member of the Domestic Violence Committee be someone from the Department of Health and Human Services that's overseeing that program. To decrease bureaucracy and long committee meetings, this will be essential to continue to move our state forward in this space. Thank you.
Thank you. Are there additional callers?
Chair, this is Felicia with Broadcast. Stand by and I'll connect with Shayna in public comment. Chair, this is Felicia again in Broadcast. It looks like public comment is having some audio issues. We're working on it at the moment.
Okay, and as we had done, Felicia, we had done support. Does that mean we might have more in support?
It is possible. I can.
Okay, we'll stand by then. Thank you.
Thank you, ma'am.
You are in the meeting now.
Thank you, Madam Chair. This is Felicia with Broadcast. Go ahead, Sheena.
Oh, you can hear me. I'm so excited. Thank you, Chair. I'm so sorry for the difficulties there. We do have another caller in support. She has been patient enough to wait on the line the entire time. Caller, you may go ahead. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
All right, good afternoon. This is Jennifer Noble from the Nevada District Attorneys Association. Hopefully I'm heard at this point. I'm calling today in support of Senate Bill 45. I am a Chief Deputy District Attorney at the Washoe County District Attorney's Office as well. And we'd like to thank Attorney General Ford for bringing this important piece of legislation forward to better serve our survivors of sexual assault and domestic violence, and to ensure more equitable sentencing in domestic battery cases, especially those involving pregnant women who have the highest chance of being murdered while they are pregnant than at any other point in their lifetime. We are in full support of the bill. Thank you.
Thank you, and thank you for your patience as we work through this on Monday. Any additional comments for support?
Chair, I will ask one more time. We are currently taking support on SB 45. Please press star 9 now to take your place in the queue. Chair, you have no more callers in support at this time.
Okay, then we'll go to opposition. Thank you.
To testify in opposition of SB 45, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 611, please slowly spell and state your name for the record. You have 2 minutes and may begin. Caller with the last 3 digits of 611, please press star 6 now to unmute yourself. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good afternoon, Chair and members of the committee. This is John Piro from the Clark County Public Defender's Office, JOHNPIRO. We are in opposition to only one section of the bill, Section 7, subsection 4A. This bill does a lot of great things. And the part of the bill that we are in opposition to is the mandatory minimum. We'd like to thank Ms. Adair and the Attorney General's office for working with us and for even their proposed amendment. We've relied primarily on the criminal legal system to fix our state's problem of intimate partner violence, but it has become an ineffective tool. It has neither deterred nor fixed the problem because we are still leading in all of the bad categories when it comes to this issue. Perhaps more focus should be on funding places like Safe Nest and other places that support victims, because housing a victim of domestic violence has shown to be the most effective way to get them out of a situation. But yet we continue to increase mandatory minimums, and that is why we are in opposition at this time. That concludes my testimony. Thank you.
Thank you very much, Mr. Piro. Additional callers in opposition?
Caller with the last 3 digits of 080, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Thank you. Jim Hoffman, JIMHOFFMAN, representing Nevada Attorneys for Criminal Justice. We also oppose this bill for the same reasons that Mr. Piro just stated. And I think this is actually going to be counterproductive to helping victims of domestic violence, because we know that from a policy perspective, one of the main drivers of domestic violence is economic dependency. Victims want to leave their abusers, but they can't afford to because the abuser is paying half of the bills. This is especially true for pregnant women because babies are very expensive. You need more money than usual to take care of one. Having a mandatory minimum of 30 days is going to discourage reporting because, half of the income is gone for a month. Victims face the prospect of not being able to pay the rent, getting evicted. That's always a problem, but it's especially threatening for a pregnant person. So this will not actually help these people get out of abusive situations. It will just discourage them from getting help. And so for that reason, we oppose it. Thank you.
Thank you very much. Additional callers in opposition?
Madam Chair, this is Felicia. Apologies. It looks like we have lost the audio again for public comment. Please hold. We will fix it as soon as possible.
We'll have our patience today. Thank you.
You are in the meeting now.
Chair, it looks like we have been reconnected. Caller with the last three digits of 318. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good afternoon, Madam Chair and members of the committee. My name is Kendra Birchie, KendraBertschy. First, I want to thank Ms. Adair, as well as the Attorney General's office, for speaking with us regarding this bill. We really appreciate the hard work that they are doing to improve our laws regarding domestic violence and sexual assault and human trafficking victims. I would like to start with thanking them for their hard work on, especially with looking at and researching the efficacy of our current laws and our current practice in how we are treating those who are perpetrating domestic violence on others. Our only concern is what you heard Mr. Pirro and Mr. Hoffman indicate is just regarding the mandatory minimums. The Department of Justice has done a study on the efficacy of increasing and having mandatory minimums, and it's found that increasing the severity of the punishment does little to deter the crime. I can say that I've had at least 2 cases involving this charge where the person who is a perpetrator, it was a first-time domestic battery. And so we are just concerned with having people who may have been involved in the criminal justice system for just this incident where there was no prior incidences of domestic battery, domestic violence, of treating them with a mandatory minimum of 30 days. And with that, I do really appreciate the Attorney General's office bringing this forward and with their amendment. And so thank you. That's my testimony.
Thank you very much, Ms. Berkey. Additional callers in opposition?
If you have recently just joined us, we are in opposition for SB 45. Please press star 9 now to take your place in the queue. Chair, you have no more callers in opposition at this time.
Thank you very much. May we move to neutral, please?
To testify neutral on SB 45, please press star 9 now to take your place in the queue. Chair, you have no callers neutral at this time.
Madam Chair, you are muted.
I am sorry. We will move to Ms. Adair and ask her if she has any final comments.
Thank you, Chair. I want to specifically thank Ms. Birchie for working with me prior to this hearing on this amendment. I would just note that we do have mandatory minimums for for the simple domestic violence battery misdemeanor. So the mandatory minimum here is not out of character or out of step with our current statutory scheme when it comes to domestic violence penalties. I also want to note that this mandatory minimum of 30 days is because of the gross misdemeanor in this case and the fact that pregnant people are of the most vulnerable during this time. But I also want to note that, as much as I respect the opinion of the NACJ and Mr. Pirro, the reverse is true. If there is, and I'm not sure I believe the deterrent effect of the mandatory minimum or the economic effect of a mandatory minimum. The reverse is true. If this amendment is not passed and we stay with the status quo, the offender could be punished up to 364 days. I would argue that a year incarceration would have a significantly more deterrent effect for reporting if we do not pass this amendment. And so therefore, I think that argument is a bit short-sighted, though I do respect their position. And thank Ms. Birchie specifically for working with us in advance. Thank you so much, committee, for hearing this bill. It's something that I find, I know it's very dear to my heart. It's very dear to the heart of our staff and Attorney General Ford. And so I want to thank you for your time and for your patience in hearing this bill today.
Thank you very much, and thank you for that information. And we will now close the hearing on Senate Bill 45, and we'll open the hearing on Senate Bill 127. This measure revises provisions related to the charter of the City of Mesquite. And if the bill presenters are ready, I think we have Senator Dr. Hardy and others ready to present.
Thank you, Madam.
Please go ahead when you're ready, sir.
Thank you, Madam Chair. Joe Hardy for the record. On SB 127, this is a charter change for the City of Mesquite that makes it more, I'll call it more inclusive to appoint city officers or officials. The people who requested this were additional 2 assembly members that wanted their names put on, Assemblyman Glenn Levitt and Annie Black. And so I've submitted those emails that they requested to you and your committee. My role for the presentation is to introduce Warren Hardy, who in one way or another has represented Mesquite literally for decades, and Mayor Alan Littman, who is, and between the two of them, they will present the bill. And we have the city manager, Aaron Baker, and 2 of the charter committee members, Brian Wigst and Adam Anderson, available to answer any questions. With your permission, I would turn the time over to them, depending on what you would like to do. Thank you, Madam Chair.
That sounds fine. Senator Hardy, we'll go ahead and ask Warren Hardy and Mayor Littman to come forward.
Thank you. Thank you, Madam Chair, members of the committee. My name is Warren Hardy, representing the City of Mesquite. As Senator Hardy indicated, I have been involved with Mesquite in one capacity or another since 1991. When we adopted this charter a couple of sessions ago, with significant help from then Assemblywoman Senator Neal, I said we've struck on the perfect charter and bragged that we never have to come back to make any adjustments. Here we are a couple of sessions later, proving me wrong, because our current mayor noticed what he felt was a weakness in our charter with regard to filling nominations for the position of city manager and city attorney. The way the legislation was initially drafted and adopted, it could lead to a stalemate in that position if the mayor is unable to get the 2/3 majority vote required for these positions. So what we're proposing here, we sent this question to the Charter Commission and asked them to tackle it and come up with some suggested legislation. The committee did that, and what this legislation proposes to do is on the issue of hiring a city manager or a city attorney, that the mayor would make the initial motion or suggestion for filling that position. If the mayor is then able to get a 2/3 majority or 4 of the 5 council members plus himself, which he'll be part of it because he made the motion, but then that individual is appointed. However, if that position fails, then we would like to have it open to the floor, open to the rest of the city council to make nominations, which then would have the same requirement for at least 4 affirmative votes. The mayor would be a voting member in all circumstances under this, although under the charter he breaks ties and has the ability to veto ordinances. So it's a pretty simple change, Madam Chair. We just think it's going to be, we haven't had this issue yet. We hope it doesn't become an issue, but wanted to do a preemptive strike here and resolve this issue. Our Charter Commission worked on it. I have on the phone Adam Anderson, who was the Charter Commission chairman while most of the work was done. He was replaced by Burton Wiest, who's also also on the line. He's the current chairman. And with that, Madam Chairman, since this was the mayor's idea, if it pleases the chair, I'd like to maybe have him have an opportunity to just say a couple of words about the need for the change.
Please go ahead. Mayor, we'd love to hear from you. Go ahead, please, when you're ready.
Thank you, Madam Chair and committee. For the record, Mayor Al Lippman of Mesquite. I had noticed this some time back, and I thought this is a minor change, but it does need to be corrected because sometimes you could run into a potential stalemate where the nomination would go to the council and they would reject that nomination of mine. Then it would go to another council person and bounce back. Eventually, to me, if we couldn't come to a consensus on the vote. With this needed change, I think it spells out quite clearly how we would go about this, and we would put together a city ordinance with the city council to decide the order of the council on the nominations, rather than just throw it open on the floor.
Thank you, Madam Chair. That, I think, concludes our presentation. If there's questions, we'd be more than happy to answer them.
Thank you very much, and we'll ask the committee if they have any questions. Senator Neal, questions?
Yeah, I did, but Mr. Hardy basically said it was a preemptive strike because I was literally like, what is the backstory to this one?
Madam Chair, Senator Neal asked an excellent question. We're attempting to avoid a backstory if we can.
Okay.
Well, okay. Yeah. There you go. There's the answer. Senator Neal, anything else you can?
I mean, no, I wanted, the little drama story and, Days of Our Lives backdrop to nomination, but I'm not going to get it today. So I'm
Madam Chair, but for the prohibition against lying to the legislature, I could make up a doozy, and maybe I'll do that online and send it to Senator Neal just so she has something.
You've so disappointed us, Mr. Hardy. We were so ready for it. Thank you very much. Any additional questions from the committee? Senator Goicoechea, please.
I'm very brief, and I know they said it a couple times, but it has been approved by the Charter Committee.
Yes, thank you, Madam Chair. And I think that's an important point. So thank you, Senator Goicoechea. Although the Charter Commission is not, it was unanimous vote of the Charter Commission, although the Charter Commission is not required to take it to the legislature, or excuse me, to the City Council for approval. We always do that as a matter of practice. In fact, since I've been representing the city, we don't bring an issue to Carson City unless we've worked it out locally. And so this was unanimous in both the Charter Commission and the City Council. So thank you for that, Senator.
you, Mr. Hardy. Mr. Hardy, Senator Hardy.
Thank you very much. Okay, additional questions from the committee? Okay, looking across, I don't see any. Okay, thank you very much. And with that, we will, if we have no more questions, we will go to support, opposition, and neutral. Just as a reminder, you have 2 minutes, and broadcasting, when you're ready, please go ahead.
Thank you, Chair. To testify in support of SB 127, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 800, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Hi, this is Annie Black, Assemblywoman in State Assembly District number 19, former City Councilwoman in the City of Mesquite. I wanted to say that I approve this bill. Thank you.
Thank you. Next caller, please.
Chair, you have no more callers in support at this time.
Thank you very much. Please go to opposition.
To testify in opposition of SB 127, please press star 9 now to take your place in the queue. Chair, you have no callers in opposition at this time.
Thank you very much. We'll go to neutral.
To testify neutral on SB 127, please press star 9 now to take your place in the queue. Chair, you have no callers neutral at this time.
Thank you very much. With that, Mr. Hardy or Senator Dr. Hardy, do either one of you have any closing comments?
Thank you, Madam Chair. I appreciate no drama and appreciate your hearing the bill for us. Thank you.
Thank you, Madam Chair. And I'd like to thank Senator Hardy and Assemblywoman Black for their support and help with this. And to you, Madam Chair, as always, for the good work of the hardest working committee on Senate Government Affairs that has a special place in my heart. So we now have the perfect charter.
Thank you.
If we proceed this, thank you.
Better be careful with that now. You know how that goes. Thank you very much. So with that, I will close the hearing on Senate Bill 127. And with that, we will move on to our work session. And I would like to remind everybody that we will not be taking testimony on the work session. However, I may ask bill proponents to participate as necessary and to ask questions as we move through. Our policy analyst, Lisa Keller, will be walking us through work session. So Ms. Keller, please proceed.
Thank you, Madam Chair. For the record, Lisa Keller, Committee Policy Analyst. And as a reminder, as nonpartisan staff, I neither support nor oppose any of the measures before the committee. The work session documents for the bills under consideration are available on Nellis, Republic, and the members. And the first bill for the committee's consideration is Senate Bill 37. Senate Bill 37 is sponsored on behalf of the Attorney General and was heard by the committee on February 8th. Senate Bill 37 provides that a district attorney is not required to present the reasons for requesting the presence of the Attorney General, Deputy Attorney General, or Special Investigator to provide assistance in criminal cases to the Board of County Commissioners of his or her county, or have the board adopt a resolution joining in the request unless the Attorney General intends to seek reimbursement for any expenses incurred in providing assistance to the Attorney General. And there were no amendments proposed for this measure. And it is my understanding that representatives from the Attorney General's office are available to answer committee questions. Thank you.
Thank you very much. Committee, any questions on this bill?
I move to pass.
Seeing no questions, we'll take the motion from Senator Gocochea. Do I have a second? Second from Vice Chair Orenshaw. Discussion on the motion? And will the Secretary please call for the vote? Thank you.
Vice Chair Orenshaw,
Yes.
Senator Goycochea,
Yes.
Senator Neal,
Yes.
Senator Hansen,
Yes.
Chair Dondero Loop.
Yes. Thank you very much. And the motion carries. And I'll assign that floor statement to Senator Gocochea.
Thank you, Madam Chair.
All right. And Ms. Keller, if you'll go ahead with our next bill.
Thank you, Madam Chair. The next bill for the committee's consideration is Senate Bill 39 and is sponsored on behalf of the Attorney General and was also heard on February 8th. Senate Bill 38 authorizes the Attorney General or any other officer, agency, or employee of the executive branch to enter into a pro bono contract with an attorney or law firm engaged in private practice for legal services if the Attorney General determines that the provision of such legal services is necessary. The bill requires the Attorney General to retain final authority over the course and conduct of any matter that is the subject of a pro bono contract. In addition, Senate Bill 38 requires that the pro bono contract set forth the specific rights and obligations of the parties. Any attorney or firm retained pursuant to the pro bono contract must prepare and maintain contemporaneous public records reflecting the work performed on the matter. Any fully executed pro bono contract be posted on the Attorney General's website, and the Attorney General submit an annual report to the Director of the Legislative Counsel Bureau setting forth information about pro bono contracts in effect. The committee will recall that at the hearing, the Office of the Attorney General proposed a conceptual amendment, which is included in the work session document, to clarify that the bill does not intend to require disclosure of otherwise privileged material, and to provide that any law firm or attorney offering pro bono legal services is deemed ineligible for outside counsel contracts with the Office of the Attorney General for a period of 1 year from the end date of the pro bono contract.
Thank you very much. Any discussion by the committee? Senator Hansen, please go ahead.
Thanks, Madam Chair. I'm going to have to vote no on this one after the hearing and thinking about it. Frankly, you could have not-for-profit political advocacy groups that would, in effect, be able to be picked up in this and, in effect, be given the credibility and the authority of the Attorney General of the state of Nevada. I'm very uncomfortable with that. It's too broad the way it's written. Gives too much flexibility to the Attorney General. So I'm going to have to be a no on this one, Madam Chair.
Thank you very much. Additional discussion from the committee? All right. If not, I would ask that for a motion.
Move amend and do pass, Chair.
Thank you very much, Senator Orenshaw. Second? Second from Senator Neal. Any discussion on the motion? Will the Secretary please take a roll call vote?
Vice Chair Orenshaw,
Yes.
Senator Goycochea,
Yes.
Senator Neal,
Yes.
Senator Hansen,
No.
Chair Dondero Loop.
Yes. Thank you very much. Pass it. Senator Neal, would you take that floor statement, please?
Okay.
Thank you. Ms. Keller, if you'll go ahead.
The next bill for the committee's consideration is Senate Bill 46, sponsored on behalf of the Attorney General and heard on February 8th. Senate Bill 46 authorizes any person employed by the Office of the Attorney General who prosecutes or defends actions on behalf of the state of Nevada or the executive branch to obtain a court order to require a county assessor, county recorder, the Secretary of State, or a city or county clerk to maintain personal information contained in his or her records in a confidential manner. In addition, Senate Bill 46 authorizes certain persons employed by the Office of the Attorney General to request that the Department of Motor Vehicles display an alternate address on the individual's driver's license or identification card. And finally, Senate Bill 46 authorizes the Office of the Attorney General to obtain permits from the Department of Public Safety to own and operate emergency vehicles in the performance of its duties. And no amendments were proposed for the measure.
Thank you very much. Any questions from the committee? Seeing no questions, do I have a motion?
Move to pass, Chair.
Thank you, Vice Chair Orenshaw. Second?
Second.
Second from Senator Neal. Discussion on the motion? Will the Secretary please take the roll call vote?
Vice Chair Orenshaw,
Yes.
Senator Goycochea,
Yes.
Senator Neal,
Yes.
Senator Hansen,
Yes.
Chair Dondero Loop.
Yes. Thank you very much. And Senator Hansen, would you take that floor statement, please?
Yes, Madam Chair. Thank you.
Thank you. Ms. Keller, if you'll go ahead, please.
The next bill for the committee's consideration is Senate Bill 47, sponsored on behalf of the State Treasurer and heard by this committee on February 10th. Senate Bill 47 authorizes the State Board of Finance to continue to issue certain interim debentures to pay for the general operations of the state beyond the current expiration date of June 30th, 2021. The bill permits the board to issue not more than $150 million in interim debentures if the state treasurer determines that the balance in the state general fund is insufficient to meet upcoming obligations, notifies the interim finance committee of the insufficiency and its amount, and includes a request to the IFC to allow issuance of interim debentures by the board. Finally, the bill provides that if the IFC does not consider the request and deliver a resolution within 15 days of receiving the state treasurer's notification establishing the maximum amount that may be issued, the request is deemed approved. There were no amendments proposed. And just a special note, the committee will recall that Senate Bill 4 of the 31st special session authorized the board to issue certain interim debentures to pay for the general operations of the state until June 30th of 2021. And representatives from the Office of the Treasurer are available to the committee.
Thank you very much. And are there any questions from the committee?
Madam Chair?
Yes, Senator Neal.
Thank you. So I will be voting no on SB 47. I can't accept the expansion of power. SB 4 came to the legislature, not just the IFC. And I also had a problem doing doing the special, but because it was a special session, because we were in the middle of the pandemic and we didn't know where our finances were going to go, I was okay for the special to agree for unpledged revenues to be a part of the conversation in a limited sense. But with making this permanent, I cannot agree with using unpledged and unrestricted revenues within this kind of power structure where within 15 days of no response by IFC, it becomes approved. And so I cannot support this expansion of power.
Thank you very much. Additional comments? Senator Goicoechea, please.
Thank you, Madam Chair. And my only question is, it has to be brought before the IFC in 15 days and request and deliver, but it doesn't really say in the bill that the IFC can deny it. I want to make sure that's on the record.
Do we have somebody from the Treasurer's Department that can answer that? Is that the protocol, Ms. Keller?
Yes, that is correct. I could not unmute myself, but the state treasurer is available.
Chair, if I may.
Please, go ahead, Treasurer Conine.
Senator Goicoechea, that's absolutely right. It goes before IFC, and then IFC has the opportunity to approve it, deny it, or change the dollar amount. So functionally under the bill, if there was a concern and the IFC didn't want to approve it, they would simply move the dollar amount to zero, and that would functionally stop the process.
Thank you, sir. Thank you, Madam Chair.
Thank you, Senator Goicoechea. Any additional comments on Senate Bill 47? Senator Orenshaw, please.
Thank you, Chair. And I respect my colleague from Las Vegas's concerns, but I think here with the oversight by the Interim Finance Committee that has been in statute now, I think for close to half a century, this is a tool that we may not have to use, but we'll have it in the toolbox if there is a need, an urgent need with our part-time biennial legislature and the difficulty in terms of getting a special session to meet and the cost and the expense. I will be supporting it, and I'd be willing to make a motion, Madam Chair, if you're open to one.
Thank you very much. Let me make sure nobody else has any comments. Any additional comments? Okay, go ahead, please, Senator Orenshaw.
Thank you, Chair. I move do pass.
All right, do I have a second?
Second that motion, Madam Chair.
Second from Senator Goicoechea. All right, any discussion on the motion? Will the Secretary please call the roll call vote, please?
Senator Orenshaw,
Yes.
Senator Goicoechea,
Yes.
Senator Neal,
No.
Senator Hansen,
No.
Chair Dondero Loop.
Yes. Motion passes. Motion passes 3-2. And Senator Orenshaw, will you please take that floor statement? Did you freeze or did I not hear you?
Oh, yes, Chair. Thank you.
Thank you. Thank you. All right, Ms. Keller, I think we have one more work session bill. Am I right?
That is correct.
Go ahead, please.
The final measure for the committee's consideration is Senate Bill 68, sponsored on behalf of the State Treasurer and heard by this committee on February 10th. Senate Bill 68 revises various provisions governing the investment of certain money held by the state. Specifically, the bill eliminates the prohibition against investment of the state's general portfolio in a reverse repurchase agreement, increases from $50 million to $75 million the maximum amount of money the state treasurer is authorized to transfer from the State Permanent School Fund to a corporation for public benefit to provide private equity funding to businesses engaged in certain industries that are located or seeking to locate in Nevada, and increases from $40 million to $60 million, the maximum allowable amount of the State Permanent School Fund the state treasurer is authorized to use to guarantee outstanding bonds issued by a school district. And no amendments were proposed for this measure.
Thank you very much. Any questions from the committee?
Yes, Madam Chair.
Senator Hansen, please go ahead, and then I'll come back to you, Senator Neal.
Thank you, Madam Chair. Question actually just came up, and that is the corporations for public benefits, the definition of that. Assuming the new innovation zone type laws pass that are currently being discussed in the legislature, would they qualify as a corporation for public benefit?
Treasurer Conine, if you're available, would you please answer that?
Treasurer Conine, for the record, absolutely, positively not. We're talking about the Nevada Capital Investment Corps, which has been in place since now Lieutenant Governor Marshall passed it. Thank you for the question.
Thank you very much. Senator Neal.
Thank you, Madam Chair. So I will be voting no on this. Although I support the public education component, and that has been functioning well, I don't support the reverse repurchase agreements. I didn't support it in 2015. I didn't support it in 2017, and I haven't changed. So I'm voting no on SB 68.
Okay, any additional comments from or questions from the committee? Okay, if not, with that, I will take a motion.
Move to pass.
Thank you, Vice Chair Orenshaw. And a second?
I'll second the motion, Madam Chair.
Thank you, Senator Gocochea. Discussion on the motion? Senator Hansen.
Thank you, Madam Chair. I am going to support the bill, but I would like an opportunity down the road to discuss this further with one of my colleagues. So, of course, if I change my vote on the floor, I will let you know, but I will support the measure at this point to get out of committee.
Thank you very much. All right, will the Secretary please take a roll call vote?
Vice Chair Orenshaw,
Yes.
Senator Goycochea,
Yes.
Senator Neal,
No.
Senator Hansen,
Yes.
Chair Dondero Loop.
Yes. Thank you very much. The motion carries. And I will assign that floor statement back over to Senator Orenshaw. Would you take this floor statement as well?
Yes.
Thank you very much. All right. And so with that, we are done with our work session. And so we will move to public comment. And broadcasting when you're ready.
Thank you, Chair. Your public line is currently open and working, and you have no callers at this time.
Okay, thank you very much. We will wait just a minute to make sure nobody joins us before we adjourn. Broadcasting, I'll just confirm that there is no public comment.
Chair, you have no callers at this time. Thank you.
Thank you very much. Hearing no more public comment, that concludes our meeting for today. Our next meeting will be Wednesday, March 3rd at 3:30. And I appreciate your attendance and thank you very much, all of you, and we'll see you on Wednesday.